almost unprecedented. We're talking about this settlement agreement between, on the one hand, the federal government, the ATF, and the Department of Justice, the DOJ, and on the other hand, the National Association for Gun Rights, and of course, rare breed triggers. What's going on here, and why I think, contrary to what you see in some forums, why I think this was actually a good idea. I'm going to be covering the top 3 objections that I keep hearing people bring up in forums and all that other kind of stuff that you guys keep sending me about this when you're asking me to do this video. I'm also going to walk you through some of the big parts of the settlement agreement, as well as a couple of the very curious and eyebrow-raising parts. But at the end of the day, I want to give a big round of applause to both NAGR as well as Rare Breed Triggers, especially Rare Breed, for hanging tough and pushing through this, and specifically for NAGR for not settling for 2 tiers of gun owners, people who are members of their fine organization and people who are not. They really went for the all-around win. You will see why. And guys, disclosures up front. I'm a member of NAGR that I pay for. And otherwise, I have no professional connections to either of these companies. So I don't get paid by them. I've never talked to anyone over at Rare Breed. Disclosures up front, there you go. I've got no axe to grind in this other than looking for the 2A win. Here's why I think this is a good idea. Guys, let's get into it. So there seems to be 3 objections that I see that people emailed me, people texted me. I see 3 objections that keep coming up. I'm going to deal with one of them right now. I'm going to deal with a couple of the big ones towards the end because we're going to kind of build towards it. So that way you can see all the chess pieces. One of them is this. Look, we were winning. We're winning in the 5th Circuit. We've got a great Supreme Court right now, probably as good as it will ever be when it comes to Second Amendment, all that kind of good stuff. Why not just take the football and just stuff it down the field? Well, it's going to be important to remember that we're not necessarily talking about a Second Amendment case. Why? We're really talking about kind of an agency case. We're talking about the fact that the ATF decided, without even passing a rule, so we're not even dealing with the Administrative Procedures Act, all that kind of stuff. The ATF just decided, you know what? FRTs, force reset triggers, these are machine guns now. We're just kind of making that call. The technical division has rechecked things out and kind of on we go. So this isn't kind of a Second Amendment case per se. We're not really dealing with Brune. We're not dealing with Heller. We're not dealing with any of those great cases. This is going to be outside the scope of Second Amendment law. Now it's inside insofar as, we are dealing with agencies, and unfortunately, our rights sometimes hinge on that, which they absolutely should never in a million years hang on that. But insofar as you've got that. But guys, 2 words, Cargill precedent. Cargill was, of course, the case that came out of the 5th Circuit, went to the United States Supreme Court, and deals with bump stocks. We won. We crushed on bump stocks, okay? Why is that important for overcoming this objection? Because let's say we keep litigating this case in the 5th Circuit. It goes up to the United States Supreme Court. What's the best case scenario? What's the worst case scenario? Best case scenario probably is the Supreme Court denies the cert, okay? Why? Because this case is basically Cargill all over again. So realistic best case scenario, they probably just deny the cert, and that's about it. Because again, it's very, very similar, very similar. They're not fingerprints of each other, but they're pretty dang close. Worst case scenario, we see what happens with Rahimi, where we get Brune, which is a fantastic Second Amendment case. And then a couple years down the line, Rahimi comes along, and now we've watered down a bunch of stuff. That is kind of some bracketing of some best case scenario, some worst case scenario. Yeah, I understand. What happens if the Supreme Court takes it and says, no ATF, you can't just arbitrarily do this? Go check that reading again for how the actual federal statute is, 1 shot per function of the trigger. FRT does not create more than 1 shot per function of the trigger. I get it. But again, we've got that with Cargill. The Supreme Court is not going to copy paste a decision. So that's why I think best case scenario is we actually get denial cert, assuming we win in the 5th, and we're going to win in the 5th. And I think everybody kind of sees that coming. Worst case scenario, we get something extraordinarily watered down that winds up hurting the Cargill decision and in fact works against gun rights in the long term. Now, I talked to the vice president at the National Association for Gun Rights, Hannah Hill. And by the way, NAGR, fantastic organization. I've been proud to promote and support them before. I will do so here again. Join NAGR, join all these groups. But today we're talking about NAGR, fantastic organization. Hannah was very generous with her time, as she always is. Thank you, Hannah, if you're watching this. And we talked through a lot of what was going on here. And one of the points that motivated NAGR to basically bank the winnings, even though they felt like, look, we're going to win if we keep going. But right now, so long as this lawsuit remains pending, you cannot just go out and buy FRTs, right? We can't. It's been shot down. While this is going on, we're seeing state after state after state pass all of these so-called Glock switch bans, right? Why is that relevant? You're going to see it here. You're going to see it a little later on. It's relevant because many of these Glock switch bans are worded by intent so nebulously that they could very easily include FRT triggers as being banned in various states as well. So if we keep litigating and fighting this out, which by the way is burning the resources at NAGR, not to mention, of course, Rare Breed itself, they're churning through lawyer resources here that could be redeployed elsewhere. So that's a reason unto itself, but we're not focusing on that. But if they get a quick win on this like they did, now that allows folks in some of these states to go out there, make those purchases so that if there is going to be a ban down the line, that, hey, if there's a grandfathering provision, if they want to comply with it, whatever it might be, they've got options. Right now, guess what? No options. So that is something that goes beyond members of NAGR. That goes for all of our Second Amendment advocates out there, anybody, whether it's past, present, future, who might be getting back into firearms, back into the Second Amendment, that is a complete win across the board for those folks to be able to jump into this before their state criminalizes it. Okay, again, subject to local listings and how that criminalization takes place. But the bottom line, pushing towards common use. That's part of this bottom line. We got to get the manufacturing. We have to get everything back in the stream of commerce so that people are buying this so that we have a stronger argument that these are part of common use. Therefore, they cannot be banned. Not going to keep drilling into that. You can hopefully take that ball and run with it. Let's get back to some of the points in the settlement agreement, which you will find linked below. I'm going to go through what I found to be the top 6 things in it, including a few of the objections. I said there are 3 objections. We've got 2 more that we're going to be pushing through as we push through these. I'm going to go through them quickly. So the first one that people need to know about comes in part 3, which says, I'm going to read in part, the United States agrees to the extent practicable to return FRTs that it has seized or taken as a result of voluntary surrender. Such returns must be requested by individual owners by September 30th, 2025. So it's an important public service announcement for those of you out there who voluntarily surrendered to the United States. So not your local PD, but you surrendered it to the ATF, the DOJ, the whoever. Okay. You have until September 30th, 2025 to make a request. Make sure you get that request in writing. Okay. Make sure you get some sort of written receipt, because after that, guess what? Too bad, so sad. Thanks for playing. Obviously, what I don't like and what other people don't like either is to the extent practicable. I can assure you, I'm sure that this was pushed as far as we don't want the extent practical. I realize that waters it down, but look, that is what it is. I'm going to come back to the extent practicable on my 6th point, which is really one of the big wins out of this. You're going to stick around. It's number 6. Okay, I'm going to come back to this in number 6. Put a pin in that. Now, originally, in some of the draft language, this was only going to be for NAGR members. And that would by no means be untypical, by no means uncommon for these sorts of lawsuits, right? That only the plaintiffs get the relief. To their credit, Hannah Hill and the National Association for Gun Rights insisted that the Second Amendment doesn't create 2 classes of gun owners, the people who are a member of some group and the people who are not. They insisted that this goes for everyone, whether you're a member of NAGR or not. That also, of course, goes against their interest, because it would have been a great selling point of, hey, you want your FRT back, come join our group. Okay, but they didn't do that. They went for the wider win, not the narrow picture win. And all credit goes to them to avoid that easy join us or else pitch that they could have made, and instead they went for the 2-way win. So good job on that. Number 2, really quickly, there's a whole bunch of hold harmlesses where everybody's agreeing to not sue one another. Everyone's going to be dismissing their lawsuits, so forth. There's really not much to talk about here. Super standard language that you see as part of any of this. But again, I create this because we're going to come back to this in number 6 down the line. So number 3 is kind of interesting because it keeps coming up, and I see it as potentially a thread that connects a lot of the subtext of what's going on here. Then my third point deals with the fact that basically the plaintiffs, we're talking about rare breed triggers and so forth, agree that they will not develop or design FRTs for use in any handgun. Curiously, it then defines handgun for the purposes of this agreement as a firearm whose magazine loads into the trigger hand grip. So think about your Glock, think about most semi-automatic handguns, right? You insert the magazine into the grip, right? And the grip houses the magazine. Okay. Why did they word it like that? Because the feds don't know what a handgun is? Maybe. I'll let you think about that. But here's what I think is going on here, is the fact that no, they weren't worried about the fact that FRT might develop triggers for the Tech 9. Rather, if you define handgun in the conventional sense of the term, you just ban their product. Because guess what? FRTs go into AR-15s, and AR-15s can easily be configured lawfully in most states, check your local listings, as a pistol, as a handgun. So they had to define handgun in such a way that accomplished the government's interests, which I'll get to in a moment, while also protecting FRT's interests, right? Rare breed triggers, RBTs, I should be saying, interests of we need to be able to be making these things for AR-15s. So that's the reason why I think, I'm speculating here, but that's, I think, what was going on with why they defined it that way to protect rare breed triggers. Why is the government so obsessed with this idea? I talked to lots of different cops. I talked to lots of different people in law enforcement, really have nothing to do with this video. A lot of those people come from Milwaukee, which for those of you who may not know is sometimes nicknamed as Kill-Walkie. Horrific gang problems, violence problems, you name it. Finding Glock switches, by no means uncommon. Now, whether the government is overreacting to this, whether we think that this is a worthwhile prioritization the government's doing, doesn't matter. Doesn't matter. The bottom line is the government thinks that Glock switches and upstroking some of the potential to discharge rounds for handguns is apparently a worthwhile endeavor for them to be pursuing at a federal level. That's what they're doing here. So that's what the government's trying to do. And I think the reason why they worded handguns that way, because I see people asking this, I think that's why they did it here, to protect rare breed triggers' ability to manufacture, distribute, and sell their core product line. Okay, so number 4 is another interesting point, which basically compels rare breed triggers to take all reasonable efforts to engage in patent enforcement, seeking prohibitory injunctions against any person or entity that manufactures, sells, or distributes any FRT during the life of the patent, provided that rare breed triggers, of course, has a good faith argument that the device in question they're seeking the injunction against is within the scope of the patent. The U.S. agrees that they will not bear any litigation costs associated with this, and later, at subpoint 14 in the settlement agreement, the United States agrees to consider, which really isn't an agreement at all, but they agree to consider filing statements in support of rare breed triggers' civil actions for injunctions against patent violators, detailing the public interest to be served by the injunctions. All right, what's going on here? The federal government perceives a very real threat for law and order of Glock switches and of things that can go into handguns that are commonly carried by gangs. I don't have my constitutional attorney hat on right now. This is me just trying to explain what I think is going on. So if they have a major manufacturer locked into agreement, agreeing that thou shalt not manufacture FRTs for handguns, then what do we want to do? We want to compel them to seek enforcement of their patent to stop other companies who might be looking to do that, who might be looking to put an FRT, some sort of forced reset trigger type, which presumably, of course, is what's protected by that patent, into handguns. What I don't think is going on here is I don't think rare breed triggers, as I've seen suggested in some forums, as well as what people have emailed me, I don't think that the federal government is being the lead blocker for them to have some sort of monopoly. Bluntly, they have the monopoly. That's what the patent is for. They have a legal monopoly to manufacture this, subject to licensing and all that kind of stuff, right? They already have that. So there's really no reason for RBT to have this here, for the rare breed triggers to have this here. I think this is something the feds want to be put in there in order to discourage any kind of R&D efforts to stick this, of any potential infringers, I should add, to be putting this into handguns, because the feds think that this should be a priority. All right. How do we then read this whole part about the fact the United States agrees to consider basically coming in and helping them out, throwing a little bit of a glancing block. I think it really comes down to the fact that they are trying to dissuade people who might be interested in infringing on the patent, of basically saying, look, by the way, guys, we might be coming in and throwing our weight behind rare breed triggers on this too, so don't do it. I think that this came from the United States' side. Rare breed triggers gets out of this exactly what they came into it with, which is they've got a patent. It's enforceable. It is what it is. No extra patents that I'm aware of were granted as part of this. So what I don't see is some sort of monopoly or socialistic collusion between government and capital to create some sort of monopoly. Again, the patent is there. It is what it is. Please excuse this brief interruption to support our sponsor. Our sponsor today is my law firm. We've got over 50 employees, over 30 attorneys, all over the state of Wisconsin. We are here in the state of Wisconsin. We handle criminal defense, divorce, and we also have estate planning. Different wings of the firm do different things to make sure that you always get the best attorney at a price point that you can afford. And if you're enjoying this and other educational legal content that I've done, well, thank you for joining me, number one. But number two, please consider dropping a 5-star review. You can find posts down that will be linked to different Google platforms. You can check out some of the details below. I appreciate you sticking around. Don't miss the quote of the day at the end of the video. Now back to the show. All right, number 5. This is a big one. Getting back to those 3 objections I was talking about, this is the second one, okay? Trigger warning, the one time I can say that and it doesn't feel cringe. So there's a section in this settlement agreement that says something like this, that the United States agrees to not enforce 18 U.S.C. 922 sub O. That's the part that says, you can't own machine guns unless they're properly registered, okay? As well as parts of the Gun Control Act, National Firearms Act, and so forth, against any FRT owner, manufacturer, distributor, retailer, and so forth, under 2 conditions. One is that it is being used as designed, so you can't manipulate it, you can't change it or stuff like that. It has to fundamentally be used as designed. And number 2, of course, it cannot be manufactured for a handgun. Once more, going back to the fact that the government's got this big boogie monster for these handguns FRTs. So that has begged the question, did Rare Breed Trigger, did the National Association for Gun Rights just leave people out to dry? And for other parties right now who manufacture maybe a competing product, again, lawyers, they're finicky creatures, man. They're finicky creatures. They only want to do things on, generally speaking, as narrow of a basis as possible. The discovery in this case, that's all the evidence gathered up, only pertains to the patent in this case. It is 0% a surprise to me at all if the government said, we will only rule as it relates to this particular patent, as it relates to these particular things. That's the only thing we have the ability to look at because it's the only thing we have been looking at. Anything else is really going to fly well beyond the scope of this particular lawsuit. So no, I don't think this is creating 2 different classes of manufacturers, 2 different classes of whatever. We're dealing with what we are dealing with. We are dealing with what was on the table. We're talking about whether or not what we're having for dinner right now is a machine gun. Not what the next restaurant next door sells. We're talking about whether or not this particular restaurant is selling machine guns. All right, number 6. This is a big one. And this gets back to the 3rd objection I told you to put a pin in before, which is the fact that the feds agree to return things if practicable. Number 6, all disputes will be litigated and settled in the Northern District Court of Texas. What a great place, if you're a Second Amendment loving fan, to have a forum selection clause. That's what you call it. It's a forum selection clause of, hey, if we have an argument about this contract, about this settlement, does that mean I can go pick a court that maybe is super anti-gun over on one of the coasts? No. We're going to be in perhaps the most pro-gun district in the country. So if you've got an issue with the fact that ATF is not returning your trigger and you don't think it's practicable of them, what they're doing, you think that it should be practical. It is practicable. Well, great. You get to go to the most pro-gun court in the entire nation, perhaps. What a great deal. If you think that there's other ways, whether in the near future or far future, where the government is violating this, where the ATF, the DOJ, those are the players we're talking about, are violating this, great. You go sue them in the most pro-gun court in the nation, most pro-gun district in the nation, perhaps, for specific performance, for injunctive relief, for contempt of court. This is what you can do. You have a host of options, and Lord knows you're going to hopefully continue to have great groups like NAGR at your back. We'll be more than happy to continue to be the spear tip on the charge for the Second Amendment. So there you go. That's my take on this. A lot of you have been asking for feedback on it. So I made some time in my day to go ahead, call some of the players. I also called Bill Kirk, Washington Gun Law. He and I talked about this as well. He may have had some sort of role into this. I don't know what he said publicly, so I'll let him describe what he did or did not do. But I talked to multiple different players behind the scenes, some things I couldn't share, most of it that I could. And I think that NAGR did a fantastic job. I completely understand why Rare Breed Triggers did this. I think that they played for realistically, as the cards in the law allow. I think they got a great outcome, and I don't see it as something that's sacrificing the Second Amendment or misprioritizing something. I think it all makes sense. Be sure to hit that like button. I appreciate you sticking around. Let's close with our quote of the day. This one comes from John Adams, who wrote, "A well-armed populace is a security for a free state. The disarmed populace is the easiest to enslave." Hear, hear, as history and time has taught us over and over again. I look forward to joining your discussion down in the comment field below. Let me know what you think about all of this, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.